Here is a summary of the May 22nd, 2025 Supreme Court order in the case called Trump versus Wilcox, case number 24A966. The question presented in this case is whether the Supreme Court should stay the judgments issued by the U.S. District Court for the District of Columbia pending appeal to the U.S. District Court of Appeals for the D.C. Circuit and any other proceedings in the Supreme Court. The underlying case involves the questions about whether the president may remove without cause members of the National Labor Relations Board and Merit Personnel or Merit Systems Protection Board, or whether statutory for-cause removal protections for these agency heads violates the president's constitutional authority under Article 2 to supervise and control officers who exercise executive authority on the president's behalf. The justices did not sign the order. Justice Kagan filed a dissent from the grant of the stay application and was joined by Justices Sotomayor and Jackson. Here's the text of the order. Because the Constitution vests the executive power in the president, he may remove without cause executive officers who exercise that power on his behalf, subject to narrow exceptions recognized by our precedents. The stay reflects our judgment that the government is likely to show that both the NLRB and MSPB exercise considerable executive power. But we do not ultimately decide in this posture whether the NLRB or MSPB falls within such a recognized exception. That question is better left for resolution after full briefing and argument. The stay also reflects our judgment that the government faces greater risk of harm from an order allowing a removed officer to continue exercising the executive power than a wrongfully removed officer faces from being unable to perform her statutory duty. A stay is appropriate to avoid the disruptive effect of the repeated removal and reinstatement of officers during the pendency of this litigation. Finally, respondents Gwen Wilcox and Kathy Harris contend that arguments in this case necessarily implicate the constitutionality of for-cause removal protections for members of the Federal Reserve Board of Governors or other members of the Federal Open Market Committee. We disagree. The Federal Reserve is a uniquely structured quasi-private entity that follows in the distinct historical tradition of the First and Second Banks of the United States. The March 4th, 2025 order of the United States District Court for the District of Columbia and the March 6, 2025 order of the United States District Court for the District of Columbia are stayed pending the disposition of the appeal in the United States Court of Appeals for the District of Columbia Circuit and disposition of a petition for a writ of certiorari if such a writ is timely sought. If should certiorari be denied, this stay shall terminate automatically. In the event certiorari is granted, the stay shall terminate upon the sending down of the judgment of this court. Here is Justice Kagan's dissent. A summary of her dissent. Humphrey's executor has stood as precedent for 90 years, undergirding bipartisan administrative bodies that carry out expertise-based functions with independence from presidential control. Congress created agencies like the NLRB, MSPB, Federal Communications Commission, Federal Trade Commission, and the Federal Reserve Board based on the vision that knowledgeable people from both parties, protected from removal without cause, would make decisions advancing the long-term public good. Humphreys established that Congress has authority to forbid their removal except for cause when creating such quasi-legislative or quasi-judicial bodies. The president has chosen to take the law into his own hands by removing, without cause, officers from classic independent agencies, something no president has attempted since the 1950s. Under existing law established by Humphreys, both the NLRB and MSPB fit securely within agencies protected from removal without cause, as they are multi-member bodies of experts balanced along partisan lines with quasi-legislative or quasi-judicial functions. The court's emergency docket should not be used to overrule or revise existing law. Emergency applications are considered on a short fuse without the benefit of full briefing and oral argument, and resolved without fully stating reasons, granting relief that changes the law rather than vindicating established legal rights, inappropriately short circuits the deliberative process needed when ruling on longstanding precedents. The majority's explanation unfolds in two inadequate parts. First, the majority purports not to decide whether the president is likely to succeed on the merits, merely stating that officers exercising executive power may be removed without cause, subject to narrow exceptions recognized by our precedents. The majority suggests these commissioners exercise considerable executive power, but leaves for future determination whether they fall within a recognized exception, meaning Humphreys. This either restates the question without answering it or hints at reducing Humphreys to nothing, depriving members of independent agencies of tenured protections through emergency relief. Second, the majority's balance of equities analysis misapprehends what this case involves. The relevant interest is not in the removed officer's personal interests, but Congress's and the public's interest in maintaining independent agencies as Congress intended. Bodies of specialists balanced along partisan lines that make sound judgments precisely because they are not fully controlled by the White House. The majority distorts the president's interest, giving it more weight than it has carried in nearly a century, when 14 different presidents have lived with Congress's restrictions on firing members of independent agencies. The majority closes by stating that today's order has no bearing on the constitutionality of for-cause removal protections for Federal Reserve Board members. However, the Federal Reserve's independence rests on the same constitutional foundations as other independent agencies, largely on Humphreys. The majority's attempt to distinguish the Federal Reserve as uniquely structured with distinct historical tradition finds no support in the cited footnote from Scalia law. The court should be bound by strict rules and precedents to avoid arbitrary discretion. Today's order favors the president over precedent, unrestrained by the rules of briefing, argument, and time needed to discipline decision-making. I would deny the president's application based on Congress's will, this court's seminal decision approving independent agencies for cause protections in 90 years of this nation's history. Here are some case implications. Trump v. Wilcox represents a noteworthy procedural development in the ongoing debate over presidential removal authority, though the court's stay order deliberately avoids resolving the underlying merits. The majority's willingness to grant emergency relief while explicitly declining to determine the merits suggests potential reconsideration of the scope of Humphrey's executor. At the same time, the actual extent of any doctrinal shift remains unclear. The court's emphasis that these agencies exercise considerable executive power may signal closer scrutiny of which bodies qualify for removal protection, though this language could equally reflect descriptive observation than legal conclusion. Justice Kagan's sharp dissent highlights the tension between using emergency procedures to potentially alter established precedent and the traditional deliberative process for constitutional questions of this magnitude. As far as an immediate case impact, the practical effect allows the president to keep these officers from working in their respective agencies while the case plays out. The majority's attempt to distinguish the Federal Reserve removal protections suggests awareness of potential economic disruption from wholesale elimination of the Federal Reserve Board. The case ultimately reflects the court's ongoing grappling with separation of powers questions in the administrative framework, but definitive implications await full briefing and argument on the constitutional merits. Hope you enjoyed this summary.